not the mental process. We're not asking you to consider any of that. We would agree that 606 would block that. But what the rule allows you to consider, and what we're asking you to look to consider here to prevent injustice and a wrong, is the result. Where every juror ended up, not how they got there. And so for example, I'm going to get into this later, but this idea that the statement that I did not believe he had an intent to kill her. I did not believe he was not guilty. I did not believe he was guilty of attempted murder. Okay, that's not the mental process. That's the result, the objective result. Why did you not think that? If she were to say, well, again, I thought the DNA blew her story out of the water. I thought it was clear there was no premeditated plan. I didn't think the eyewitnesses were overly credible. I thought the cops were exaggerating. That's the mental process that we're not asking you to consider. How they got where they got is different. And the policy behind 606 and striking this balance, it makes a lot of sense. It makes a lot of sense. And from the commentary, it says, Rule 606 commentary, it is meant to strike a proper balance by excluding testimony relating to the internal deliberative process and allowing testimony about objective misconduct and irregularities. So irregularities, if there is objective evidence of irregularities, you must consider it, obviously. Because if not, then we're letting this rule of evidence trump everything we know about the Constitution and due process and the right to a fair trial. And that's what they want you to do here. Use a hyper-technical application, well, not even that, a wrong interpretation of a rule to override constitutional rights to a fair trial, to a unanimous verdict, to due process. And that's why when they drafted this rule, they didn't do that. They struck that balance so that courts, when fortunately, not by anything we did, but on the juror's own voluntary statements to the media after, when it is uncovered that there is an irregularity, as we have here, it allows the court to do something about it. And that's why the rule is written the way it is. HRE, this is from State versus Holbrown, 80 Hawaii 27. HRE 606 does not foreclose judicial inquiry into irregularities affecting verdict integrity. And that's what we're saying here. And to interpret the rule the way they're interpreting it, or asking you to interpret it, would render it unconstitutional. We all know that rules can't trump the Constitution. But you don't need to do that. You interpret it the way the plain language says, and it can all work together. Then okay, we apply the rule the way it's meant to be applied, and we apply the Constitution the way the Constitution is meant to be applied. And that's the thing. I guess if when the rule says you cannot consider their mental processes and everything I just mentioned, what do they think that means if it blocks what we're asking you to consider? If it blocks what we're asking you to consider, then that doesn't mean anything. That means you can't consider anything. And so clearly the rule allows you to consider some things. Let's look at then, with that application, what you can consider and should consider. The statements to the media and the declaration of the foreperson. The foreperson's statements to the media, it's all in our motion. I know you read it. The intent to kill is improbable to us. The jury did not believe Dr. Konig intended to kill Arielle Konig from her affidavit. From her affidavit, I believe Dr. Konig was not guilty of attempted murder. From her affidavit. Sworn statement that that's why we did this, because if there's any doubt she said that, by all means, go interview her, which they did. And I don't know how they went about it that made her uncomfortable to talk to them and didn't record it. But now, in a report that's generated the day after a reply is due, or at least produced well after, but the point is she verified that what was in that affidavit was true. So what does that mean? She has told the prosecutors that what she said, I believe Dr. Konig was not guilty of attempted murder, that's a true statement. Juror number 3, I don't know if he was trying to kill his wife, but he had the capacity to kill his wife. Now here's the thing. Here's the part I frankly don't understand. I'm not so sure what the prosecutor is saying today about this, because the opposition was filed when it was filed, and presumably they meant what they said in their opposition. And let's look at what they said in their opposition about what you can consider. And it's on page 17 of their opposition that was filed by the state. Obviously, we have duties to the court when we file things, that we mean what we say. What evidence, this is their words, what evidence is left after HRE 606B is applied correctly is Exhibit D and statements number 1, 3, and 4 of the foreperson's affidavit. Statements 1, 3, and 4 of the affidavit. Statement 1, I was the foreperson. Statement 3, the jury did not unanimously believe that Dr. Konig had an intent to kill his wife. They are conceding in their opposition filed in this court that you can consider that properly under 606. Statement number 4 from the affidavit. I did not believe that Dr. Konig had an intent to kill his wife during the incident on the Makalapua Trail, and I believe he was not guilty of attempted murder. They concede you can properly consider that under 606. And at first I thought, is that a typo? And then I read what's before and after, and it's clearly not a typo. They believe that the application of 606 precludes, as I've talked about, mental deliberative processes, but doesn't preclude, an objective irregularity, result-oriented kind of comment. So they themselves say you can consider that. So let's summarize then with what they concede, what can and be properly considered, even by their own admission. Again, the intent to kill is improbable. Did not know if he had an intent to kill. Jury was not unanimous as the intent to kill. And a foreperson believed she believed he was not guilty of attempted murder. So, if you can consider, and because you can't consider all of that, the verdict just cannot stand. It just can't. It's undisputed how your instructions worked and how the law worked. Nobody, I think, is disputing that. There must have been a unanimous agreement to guilty on attempted murder before they could even consider extreme mental emotional distress manslaughter. We all know that. We all know that. We have a juror saying, I didn't believe he was guilty of attempted murder. I didn't believe he had an intent to kill her. So, and if it was not unanimous, the instructions then direct them to go to the assault charges, which did not happen. And, I think we can all agree that even for us lawyers, the instructions are complicated. So I'm not faulting the jurors. I mean, they're human, they're trying their best, but mistakes happen. Misunderstandings happen. And that's not a failure of the system. What's a failure of the system is when we learn about that if we don't take steps to correct it. And that's the way the law works. And if there is an irregularity, there is an irregularity